Okay, everyone. Welcome back. Good morning, good afternoon, good evening, and good night. So, this time, let's discuss the salient points, just an overview of the cases which I have assigned to you. So, first, let's talk about Commissioner versus UMEX Philippines Corporation. No? Commissioner versus UMEX Philippines Corporation. Um, Although the case is talking about improperly accumulated earnings tax, what I would like to emphasize in our discussion here is with respect to the due process requirement for the assessment of taxes. Okay, so just a brief background of this case. UMEX Philippines is PEZA registered and was assessed by the BIR for deficiency taxes. Now, the deficiency taxes of UMEX composed of deficiency income taxes, other taxes, and of course the improperly accumulated earnings tax. On December 16, 2010, the PAN or the pre-assessment notice was issued. And then later on January 10, 2011, the formal letter of demand with the final assessment notice was issued as well. Now, both the PAN and the FAN were received by the taxpayer on January 18, 2011. No? Thereafter, the taxpayer filed its protest on January 20. So dali ra kayo, di ba? In a matter of 2 days. So again, no, the PAN and the FLD FAN were received by the taxpayer on January 18, 2011. The taxpayer protested, and then surprisingly, on February 4, UMEX Philippines paid partially, no, the assessment issued by the Commissioner of Internal Revenue. So the other taxes were paid, or the other deficiency taxes were paid by UMEX Philippines Corporation. Of course, UMEX continued to dispute the improperly accumulated earnings tax, or the IAET. Now, one common point here, frequently mentioned in this case, is Section 228 of the Tax Code and Revenue Regulations number 12-99, which grants a taxpayer a period of 15 days within which they can reply to the preliminary assessment notice. No? So, according to Section 228 and Revenue Regulations, or in relation to Revenue Regulations 12-99, the taxpayer has 15 days from receipt of the PAN within which to reply. Okay, so that's just a background of the law involved. So, what did the Court of Tax Appeals Division and NBank decide? No, bago sakto ba ito pagka-pronounce? Sorry na lang. No? What did they decide? No? According to the CTA, the assessment was illegal because the FAN or FLD was issued without giving the taxpayer the time to respond to the preliminary assessment notice, which is tantamount to violation of procedural due process. So again, if you remember what we mentioned earlier, the PAN and the FLD FAN were received on the same date, January 18, 2011. Okay. Now, what was the ruling of the Supreme Court in this case? No? Anyway, those are just one. No? What was the arguments, rather, of the Commissioner of Internal Revenue in this case? According to the Commissioner, well, the taxpayer was afforded due process because there was already constructive service of the preliminary assessment notice. Because if you go back to the facts of the case, the PAN was mailed or sent out on December 17. And the BIR had not received a response within 15 days, so they issued the FLD FAN on January 10, 2011, or the next year. No? According to the commissioner, again, in another argument, is that, well, UMEX was still afforded due process. In fact, they were able to protest. So if you recall again, no, 2 days after receiving the FAN, they protested, no, on January 20, 2011. And aside from protesting, they even paid, no? They even paid some of the deficiency taxes in the FLD FAN. So on the part of the commissioner, they're saying that uh, you're not deprived due process. In fact, you were able to protest and you were able to pay. Okay. Aside from that, another argument of the Commissioner of Internal Revenue was that, uh, well, the assessment had a proper factual basis because assessments are presumed correct. So, anyway, let's continue. What was the argument of UMEX? So, according to UMEX in this case, well, there was no constructive service. In fact, we can easily prove that we received both the PAN and the FAN on the same day, which is January 18. No? And besides, no, subsequent protest and payment did not cure the nullity of the assessment. No? So, this was the argument of UMEX. No? What was the ruling of the court? So, again, if you look at Section 228 and Revenue Regulations 12-99, you can see there that the taxpayer is given 15 days to respond or reply to the PAN, okay? Only after receiving the taxpayer's response, or in case of the taxpayer default, can the respondent issue the FLD FAN, okay? So, the Supreme Court in this case reiterated the mandatory requirement that the PAN should be issued before the final assessment notice. No? So, just to emphasize, no, gibalik-balik ni sa, in this case of Commissioner versus UMEX. Under Section 228, it is explicitly required that the taxpayer be informed in writing of the law and of the facts on which the assessment is made. Otherwise, the assessment is void. No? Section 312 of Revenue Regulations 12-99 requires the preliminary assessment notice to show in detail the facts and law, rules and regulations, or jurisprudence on which the proposed assessment is based. No? And even in the final letter of demand and final assessment notice, it must also state the facts and law on which it is based. So again, what is the consequence if the facts, the laws, the rules and regulations or jurisprudence are not indicated in the PAN or the FAN? The consequence there is that the assessment notices will be void. Okay, so it is that impactful. It's that important. No, so that's also part of the due process requirement. No, that the facts, the laws, the rules and regulations, and the jurisprudence upon which the assessment is based shall be indicated in writing. Now, not only the assessments or the final letter of demand should indicate the laws, the rules and regulations or jurisprudence, but also the decision of the commissioner on the protest of the taxpayer should also indicate the facts, laws, rules and regulations or jurisprudence upon which it is based. Otherwise, this would invalidate the assessment again. No? So you can see how the due process requirements are laid down in our existing rules. No? Now, the Supreme Court said the use of the word shall indicates that the requirement of informing the taxpayer of the legal and factual basis of the assessment and the decision made against him is mandatory. This is an essential requirement of due process and again applies to, so take note of the three, wherein it must be wherein the laws, the rules and regulations, the jurisprudence must be indicated, okay? The preliminary assessment notice, the FLD FAN or the final letter of demand with the final assessment notice, and the final decision on disputed assessment. No? So these three notices and decision should include the laws, the rules and regulations, and jurisprudence upon which it is based. Otherwise, they will be considered as void. So this is what the Supreme Court emphasized in this case. Now, on the part of the taxpayer, again, they're given the opportunity to explain or present their side throughout the process, no? From tax evasion, from tax investigation through tax assessment. No? So in the notice of informal conference, the taxpayer is given within 15 days to respond. No? In the PAN, 15 days from receipt to respond as well. In the FLD FAN, 30 days to protest. So, citing the Metro Superrama case again, the Supreme Court reiterated the mandatory requirement that the PAN must be sent first before the final assessment notice. No? It is clear that the sending of a PAN to the taxpayer to inform him of the assessment made is but part of the due process requirement in the issuance of a deficiency tax assessment, the absence of which renders nugatory any assessment made by the tax authorities. No? So the use of the word shall describes the mandatory nature of the service of a PAN. The persuasiveness of the right to due process reaches both substantial and procedural rights, and the failure of the commissioner to strictly comply with the requirements laid by law and its own rules is a denial of MetroStar's right to due process. Okay. Now, in balancing the scales again, no, between the state's power of taxation and the right to due process and the equal protection clause, which one will prevail? Of course, it's the taxpayer's right to due process and the equal protection of the laws, because these are constitutional rights amply protected by the Bill of Rights. So, okay, let's talk about the Supreme Court's ruling on the different issues raised by the commissioner and UMEX. So, citing this case of Pilipinas Shell Petroleum, so while PSPC indeed protested the formal assessment, such does not denigrate the fact that it was deprived of statutory and procedural process to contest the assessment before it was issued. No? So this was the ruling of the court with respect to the issue as to whether UMEX was deprived of due process, considering na nakafile pa siya og protest and considering na nakabayad pod si UMEX. No? So the Supreme Court said that, well, even if UMEX was able to file a protest, even if UMEX was able to partially pay, it does not change the fact that UMEX was deprived of statutory and procedural due process. No, so on with respect to the partial payment made by UMEX, the Supreme Court said that neither does the payment by respondent of the other items in the FLD fan preclude it from questioning the validity of the issuance of the assessment notices. The manner by which the assessment is issued is a distinct matter in itself from the contents of the assessment. No? So the payment UMEX is again not necessarily an outright waiver of its right to question the impropriety of the issuance of the assessment notice. The fact that respondents' right to due process was violated because it was denied the opportunity to respond to the PAN remains glaringly evident and cannot be deemed erased or cured by respondents or UMEX volitional or voluntary payment of other assessed items. So with respect to constructive notice, the Supreme Court, or rather, the commissioner earlier argued that there was no denial of due process because that was considered as constructively served upon UMEX Philippines. So, what did the Supreme Court say on the issue that the PAN had already been constructively served upon UMEX? The Supreme Court said that if you look at Section 3.1.2, it grants the taxpayer a period of 15 days from receipt of the PAN to respond. On the other hand, if you look at Section 3.1.7 of Revenue Regulations 12-99, this talks about constructive receipts of notices, no? Notices in general. It did not talk about the preliminary assessment notice specifically. So again, if there's a conflict between a specific provision and a general provision, which one will prevail? It is specific provision. So in this case, the Supreme Court said because Section 3.1.2 is a specific provision covering the preliminary assessment notice, then this is the provision that we will follow when it comes to determining whether the PAN has been validly issued. No? So in this case, the taxpayer was deprived of the 15-day period to respond as provided for by Section 3.1.2. So the reliance on constructive service is not justified. No? In fact, the BIR could have easily verified from the post office as to what was the date of receipt by the taxpayer. But the BIR or the commissioner did not. No? So on the issue of presumption of regularity of the assessment, this was debunked by the Supreme Court because there are other revenue regulations cited by UMEX which would show that it was exempt from the improperly accumulated earnings tax. Now, so again, the presumption of the correctness of the assessment does not apply to those made without factual or legal basis. Now, so in this case, UMEX was able to adequately show that there was a revenue regulation uh, exempting them from that coverage improperly accumulated earnings tax, and they were able to show that factually, no, they were able to show factually that they did not improperly accumulate earnings. Okay. So another case, you have Pepsi Cola Bottling Company versus Municipality of Tanawa. No? So this, just gonna dive into the issues of this case. This covers the taxing authority of the LGUs and also double taxation. Okay. Okay, no. Sorry, sorry. So you have two ordinances here. Ordinance number 23, which levies and collects from soft drinks producers and manufacturers a tax of 1/16 1 centavo for every bottle, no? For every bottle of soft drink cork. No? Later on, around a month later, there was another ordinance issued, Ordinance number 27, collected on soft drinks produced or manufactured within the territorial jurisdiction. But this time, it was a tax of 1 centavo on each gallon of volume capacity. So these were the two ordinances in question here. What Pepsi Cola tried to question in this case was whether the LGU had the power to tax, no? And whether Ordinance number 23 and 27 was tantamount to double taxation. No? So of course, it has already been well established that local government units have the power to tax. Now, this is just a reiteration of the nature of the power of taxation. In this case, you have the power of taxation is an essential and an inherent attribute of sovereignty, belonging as a matter of right to every independent government without being expressly conferred by the people. It is a power that is purely legislative. The exception, however, lies in the case of municipal corporations to which said theory does not apply. Legislative powers may be delegated to local governments in respect of matters of local concern. No? In this case, this was the issues covering this case was under the old constitution, but again, in the present constitution, it is expressly granted there that each local government unit shall have the power to create its own sources of revenues and to levy taxes subject to such limitations as Congress may provide. No? Now, just mentioned in passing by this case, so I'll just like to mention this here also for emphasis. In this case of Pepsi Cola bottling versus Tanawan, the Supreme Court also laid down some requisites for a valid tax. No? So the taking of the property is in the lawful exercise of the taxing power as when the tax is for a public purpose, the rule of uniformity is observed, the subject of taxation is within the taxing jurisdiction, and there was proper notice and opportunity to be heard, provided the assessment and the collection of the tax. So this is not a hard and fast rule as to what constitutes a tax, but it's already also comprehensive. So you can use this in your answers probably if it is being asked in the bar exam. So also in the case of Pepsi Cola versus Municipality of Tanawan, it was indicated here when the due process clause is usually violated. No? Under what instances? So just some examples. You have if the power taxation is used for a private purpose instead of a public purpose, then the due process clause can be invoked. If the tax is imposed beyond the state's jurisdiction, then the due process clause can be invoked. Or if if the collection is unjust, it's arbitrary or oppressive, then the due process clause can be invoked. No? So, on the issue of double taxation, which we have also mentioned in a previous discussion, no? Is double taxation prohibited in our jurisdiction? Again, it is not prohibited in our jurisdiction. No? So long as it does not amount to direct double taxation. No? So you have the same purpose, same subject matter, same kind or character of tax, same taxing authority, same jurisdiction, same taxing period. Okay. So if any of those elements are absent, then it's not prohibited because it is not direct double taxation. Now, with respect to the ordinances in this case, there was no double taxation because Ordinance number 27 was intended to repeal Ordinance number 23. They did not operate simultaneously. Okay. Okay. No. Uh, just for there, I'll just pause this for a bit and continue. Okay.